And then I think Warren wanted to talk about code violations. I'm sure you guys all share that in common. So if you look at I brought some materials, and there's a couple of things also I want to cover after that, if we have time, that I think it might be important as landlords that you'd be aware of too. But the bulk of this presentation is going to be about the eviction process. So I wrote an outline, and you can follow along. Raise your hand if you've ever been through the eviction process and you've done it yourself. Okay, so interesting. Only half of you basically, huh? And the other half of you, how did you guys handle it? You just lucky or?
You.
Oh, I do. I did. Okay. All right. Well, the eviction process can be kind of complicated. Not that complicated. So basically, there's 3 ways to evict somebody. And the first way is they owe you money. They're behind in rent. The second way is if they violate a rule. And third way is you just want them out completely. All right. So as you probably there's something what's called a 5-day notice. You have to first distribute. If they owe you money, the first way is to do a 5-day notice, a notice to quit. And I provided some templates. You can have those, keep them, fill them out yourself if you've never used them before, and use them. Now the 5-day basically is if they owe you any money at all, you serve them a 5-day notice. The 5-day, and we'll go into the service that. Second rule is if they violate a rule, if they're making too much noise, like they breach their lease by police disturbances, domestic violence. They call you, basically threaten your family. I've had tenants threaten the property manager's life before for some reason. I don't know why they did that. And so they violate the rule. They cause a public disturbance, public nuisance. They want them out of there. 10-day notice. It's because they breached the lease. Now you need a lease for that, technically. And then the third way is to do a 30-day notice. So they don't owe you money. They haven't breached anything, but let's say they sell the property, or you sell the property, there's a new owner. Time to move on, and you give them a 30-day notice. So how do you serve this notice to quit? Well, anyone, as far as the notice to quit, anyone can serve a notice to quit. It could be you yourself. You can hire a property manager. You can have a lawyer do it. You can have anyone do it. So that's the good news. You don't have to hire the sheriff or process server. How can the service be? How do you do it? The most common way and the most effective way is personal service. You have to hand it to them in person. Can't post it on their door. A lot of you do that. Technically, you're not supposed to. Now, 90% of the time, even if you do post it on the door, they're not going to object anyway, so you're probably going to get away with it. But technically, if they hire Peoria State Legal Services, then they could raise an objection, and then you'll have a problem. So personal service. Second way is to serve it someone who lives there, 13 years or older. And the third way is by certified mail. But you're going to need a return receipt for that. So the good news is, though, anyone can sign off on it. Anyone can sign off on it. They don't have to be the actual tenant that lives there. Now, what happens if there is no? I get a lot of calls from landlords. Well, they're avoiding me. I've been there 3 times. They're not going to sign off. They're not going to sign for my certified mail. What do I do, Mike? You can do constructive service. Now, I haven't done this technically yet. And I haven't presented it yet because I've always been able to, you guys have always been able to do it, or an objection was not raised. But technically, there's a case law where you can do constructive service, where if you can show that they're intentionally trying to avoid service, then you can show constructively, by text or by email or what have you. I haven't tested it yet in Peoria yet, but there's case law that's established. All right, so after you serve them the notice to quit, you will either wait 5 days, you wait 10 days, you wait 30 days, then what happens? Well, if they're still there and they're refusing to leave, then you gotta file your summons and complaint. So then the first thing you gotta decide is, well, do I wanna file for money judgment, or do I wanna file for possession only? Now, I usually advise my clients, Well, if they had no money to begin with, then why would you want a money judgment? Because even if you get a money judgment, it's just a piece of paper saying that they owe you money, and what good is that, you know? Then you're gonna have to try to garnish their wages and whatnot, and it's difficult to do that because a lot of times they're ungarnishable because they don't make enough, you know? But sometimes people want to prove a point. Sometimes they do have good jobs too, you know? So you gotta decide whether you wanna do possession only or money judgment. Possession only in Peoria County, the filing fee I think is like $125. The filing fee for money judgment is $282. So there's a fee difference as far as that's concerned. After that, you have to get, after the quick claim period ends, you have to file your summons and complaint. Now your complaint must include the lease, if you have a copy of the lease. Now if you don't have a lease, then you don't have to include that. But you have to include an affidavit stating why there is no lease. If you don't include that, the case can get thrown out. 2, you also have to include that rental assistance information. If you don't, a lot of landlords don't do that for some reason. If you don't include that, the case can get thrown out if they object to it. So you gotta include that information. Peoria County evictions occur and you can basically choose a court date. Everything's through e-filing. Peoria County is every Tuesday at 9 a.m. and 1:30. So you gotta choose a hearing date. Tazewell County is every Wednesday at 1:15 p.m. Now I like to usually allow I usually hire a process server. Some of you might use the sheriff, but you have to have a certified process server or the sheriff to serve your summons. Now that does need to be done by someone certified. You can't do it yourself. There's no way around that. I like to use Manlius Detective Agency. I included their phone number in case you use them. Terry is basically been doing this for a long time, and she's diehard at this. So I recommend if you're looking for a process server, even if it's for the 5-day, do that. Use her. But I like to use. I usually schedule 2 weeks ahead of time to allow her time to do it because sometimes she complains if it's too short notice. If you do use the sheriff though, remember to file an affidavit. Because a lot of times, like I was in Tazewell County just the other day, and she was just sitting there, the landlord, and I said, well, do you have an affidavit? Do you know if the sheriff served her or not? I said, I don't know if the sheriff served her. I hired the sheriff. I don't know if, I'm assuming the sheriff did their job. So the sheriff, sometimes you gotta call the sheriff, you gotta contact them ahead of time. Technically, they're supposed to mail you their affidavit of what they did or didn't do. But whatever it is, they don't file that affidavit. You gotta e-file that yourself. If you don't e-file that yourself, the judge isn't gonna know what to do. And they think you have no service. So you might have service all along. So if you get an affidavit, you gotta file that, e-file that. Service must be at least 3 days prior to the hearing date. So that means if in Peoria County, if it's every Tuesday, the process server has to file at least by Saturday in order for it to count. So keep that in mind. So if you are tight for, maybe you could, you could file it, that week and then have a hearing date that Tuesday. It's pushing it, and the process servers don't like it. But technically you could because service it can be done by that Saturday. Also, you can appoint instead of having to hire a detective, you could, and Warren could mention this, you could ask the court to appoint a private process server. Warren has his own people, and he asked the judge to appoint private process servers. And they have no special certification or whatnot. So as long as you do that, that's fine too. So next is after you serve them, then comes the hearing date. Or what happens at the hearing date? You need to talk to the tenant. Don't expect the judge to do anything that day. You gotta talk to the tenant and try to come up with an agreement if you can. Because the judge won't make a decision right there and then. The judge will ask you, well, what have you come up with? What are we doing here today? What's going on, So you try to talk to the tenant, try to come up with some type of solution. I like to come up with agreed orders. The tenant will agree to move out on such and such date. The tenant will pay this, the tenant will do that. So we work out a payment plan, and then it's all in writing and it's signed by the judge. And then what happens then, if it's violated, then you get automatic possession in that agreed order. That's what I like to do. If you can't come up with an agreed order, the judge will set a bench trial. I've also, this is important, in your order, and usually there's a standard form, so the language is in there, but if for some reason your handwriting, the order, make sure that this sheriff's spread move out language is included in your order. And I copy and pasted it for you guys. If that's not in there, even if you get a judgment, the sheriff isn't gonna move these people out. So you gotta make sure that language is in there. Usually it's in there in the template. Sometimes if you do something weird, it's not. Also, make sure you include the language, any and all unknown occupants. Because something to do with the computer system over there, sometimes it doesn't include that any and all unknown occupants. So you gotta make sure, you gotta look for that, make sure that's always included in your judgment. Because what happens then is you might get, like the tenant, you're out, but you don't get their kids out. Or you don't get their husband out, you don't get their boyfriend out. So you wanna make sure that you have any and all unknown occupants in there too. All right, so let's say you can't come up with an agreed order, and the judge sets it for trial. Well, then what happens? Well, then you gotta do a bench trial. Three most common defenses I've seen, most common one is, this place is uninhabitable. This place, there's mold, there's this, even though there's not, there's, they lied, there's this, there's that. And that's a very difficult standard to overcome on uninhabitability. And usually what happens is you have to show, they have to show the defect, but they have to show that the money that they would have paid you guys, the landlords, instead they use that money to fix the place up themselves. And they have to show documentation and receipts of that. If they don't show that, then it's they can't prove their case. So the money that they would have gone toward rent is instead of trying to fix the place up for habitability. So you gotta look at that. Another common defense, and by the way, that's a very difficult situation. Just because you got holes in the ceiling doesn't mean it's uninhabitable. Just because you got scratches in the door doesn't work, or there's a breeze coming through, doesn't mean it's uninhabitable. It's a very difficult standard, but it can be proven, Two, another common defense is I had a prior agreement with the landlord. The landlord was supposed to fix this. I had an agreement with the landlord that if I fix this and this, he would knock off this rent, and therefore I don't owe anything. And that's all oral, so it's a he said, she said kind of thing. So then, you're just gonna have to, unfortunately, you're just gonna have to, present your case. But you see that a lot too. And then the third common thing I see is improper notice. They may say, I didn't know about this 5-day notice until this trial date, and that's because maybe the landlord posted on the door and it fell off or something, Then you gotta make that whole constructive argument case. But those are the three things that I see a lot. If you do go to trial, make sure you have witnesses. Some of you have property managers, some of you do it yourself. But make sure, this is just like a TV or a movie. You can bring your witnesses, have them testify. No, there's no mold here. It was fine when it was fine when they moved in. They did this, they did that. They did it to themselves. Make sure you have witnesses lined up. Because if you don't have witnesses and it's just your testimony, there's a good chance you'll probably lose, and it's your word against theirs. So make sure it looks a lot better if you have witnesses lined up. And then if you have photographs, show your photographs, Posting. This is something that a lot of landlords don't know about or do. If you can't get service, and the process server or the sheriff can't do it, you can ask the judge for a posting order. As long as they made a diligent effort to do it, you file the affidavit, you show the judge the affidavit, and you ask the judge for a posting order. And then the judge then grants it, and then instead of having to do a personal service, then the sheriff can just do the service by posting. And what happens then is they post it in 3 public places, and then they mail it to the tenant, and then if they don't show up, you get default judgment. But you can only do that for possession only. So if you're asking for a money judgment, you can't do a posting order. And I thought it was important to know that the posting order to the sheriff must be made 10 days before the hearing date. And in Peoria County, they only do it on Fridays. So if you do it, if it's every Tuesday, and you have a new hearing 2 weeks from that Tuesday, you have to turn it in by that Wednesday or Thursday. And the sheriff does not like it when you do it like last minute, like a Thursday. So you basically gotta do it that same Tuesday or Wednesday, or else they get upset. So you gotta keep that in mind. So either A, you gotta make it like 3 weeks out, or make sure you get your posting order, you submit for posting order right away. So that's all I have for the eviction process. And I think Warren would like to maybe talk to you a little bit about code violations, and there's some more things I think I'd like to bring you about, talk about as far as immigration. There's some new laws that passed this year that affect the landlords, and there's some language regarding floods I think you should include in your lease. And so we can talk about that, and then I can answer your questions. Warren, you want to?
Well, thank you for letting us be here today. I just want to say a couple words about code violations. I don't know if any of you have had any trouble with code violations. But when you get a code violation, of course, the first thing you got to do is to try to correct the issue. But sometimes we get in a dispute with the inspectors about what you have to do and what you don't have to do. Am I right? So if you get into that situation, obviously you're going to meet with the code inspector or whatever, and you're going to argue, or you're going to present your side of the story. But if you get into a real bad code violation case, and I've handled those before, you understand that at some point in time you're going to have to say, hey, we don't agree with it, we're just going to go to court. Now, you know they have a hearing officer. All of you know that you got to be careful about that hearing officer, because you know what they've done in the past, which they're still doing. If you don't show up, they fine you $125,000, right? And that's BS, okay? But unfortunately, if you don't remedy that situation, file an appeal or whatever, that can be a legal judgment on you. So you don't want to take that for granted. But obviously, if you show up, if you meet with the inspector, if you disagree, you have some options. One option is to go to trial. Another option is, which I've used architects, I've used engineers, which I have in Galesburg. I've handled contractors that come in. I've handled all those to come in and testify over at room 203 at the courthouse. And the last one I had, which was a major one, I won it. They tried to tear the house down, but I brought an engineer, I brought an architect, I brought a plumber, I brought about everybody, and it kind of irritates you. So the only points I would make is, number one, try to settle it. Number two, if you can't, and you get into real beef, get an expert or get someone to come on your side. And then if that don't work, I guess just ask for a trial, or maybe get someone to represent you and go to a trial on it. There's one comment I gotta make about these code violations, and I've been thinking about it. It seems to me, do you think that they're picking out certain landlords and maybe getting them to, attacking them more than others? I believe that there may be a factor in that. It seems like I've had several. I've got one going on right now on a porch on a house. And I had a contract to do all the work, and then they come up and said, well, it's not good enough. We gotta have an engineer, or we're gonna come over and inspect it ourselves. They haven't done that yet. Okay, but they're going to probably. And the question then, what do I do with this porch? We reframed underneath the porch and so on. But here's one of the rules. You don't have to make everything new. And they say it's gotta be up to code. I question that. It doesn't necessarily have to be up to code, because a lot of your properties are grandfathered in. And you know what I mean by that? If they're grandfathered in, all you have to do is maintain the way they were. You don't have to build them new. So, I've got an issue with that in my porch right now, and quite frankly, I'm going to have my guy look at it. If that don't work, I may just build a case on it. So, be careful about that. Code violations. I've had a code violation where someone made me build a whole new room on the whole house, and the house right next door has got a porch falling down. And when we said something to them, they said, "Oh, that don't matter. We don't care about that." So what do you think of that, huh? Well, anyway, if you go to trial, you have the right to appeal to the circuit court, and then you have the right to appeal to the appellate court. And I wouldn't be opposed to doing that. The last one I did, I noticed it up to the circuit court, and after that, you go to the appellate court. I'd like to see a few more of these cases go to the appellate court to see what rights the city has to have and whether it is borders on harassment. And I might just say, if you think that you're being harassed by the city, maybe all you as landlords ought to get together, and maybe we ought to go against them and say, hey, your approach is really harassment. In fact, they've got JMAX, all of you know JMAX, and they go around and they pick up your little boards and pick up little things that you don't even know were there, and then they send you a bill for $300. Did you get any of those?
Yeah.
Well, first of all, you want to get photographs of what they did. And secondly, I question a little bit about what they're doing and whether that is an infringement or whether that is illegal for them to go in and do something and then send you a bill. As Mike said, he and I discussed it. If you're there, if your tenant is there, you're there, they can't come on your property. But if you're not there, they can come on your property. So on that JMAX deal, I questioned them. I have another case on JMAX that my daughter was working on, and she had someone go do the work, and then they sent us a bill for like $1,500. And the only thing of it is, she had the pictures of the job that was done before JMAX came in. And she had a meeting with the city on that one. So we better be careful about JMAX coming in and just doing whatever the hell they want to do. You know what I mean? So that's about all I really have to do. If there's any questions on codes, talk to me or Mike. And yes.
Got a question for you about this, them coming on your property. If you have no trespassing signs out, does that give you any recourse on JMAX coming on your property if you're not there? Would that give you any?
Well, if they come on your property, I think it would be a defense on any claim that they make against you. It would be the same as any other defense on a criminal case, quasi-criminal, by stopping you or detaining you or things of that nature. So I would be careful about that. And again, I don't know if any of you had much trouble with these codes or not.
City treats non-owner occupied different than they treat owner occupied.
Yeah.
Absolutely.
That's the bullshit.
Well, that's a possibility, of course.
Cause you can have a house
I've
falling
had-
down, like you said, next door.
We've had a lot of clients, and Mike knows this, who come to us on the issues of the city where you have to sign up, you pay for the city. And by the way, that's due, next week? The 27th?
28th, yep.
And whether you sold on contract for deed. Obviously, I've known some people that put out a contract and say, you're buying the house at $700 a month, right? And then when they don't work out, you say, well, you're out, I'm gonna throw you out. Well, that's the problem. You can't just evict somebody in that situation. You have to go through a formal procedure under the statute to serve notice and let them recoup and things like that. Am I right, Mike?
Right.
So if you're doing that, be careful about that, But Anyway, I think we ought to all join in together, and if we have some issues like that, maybe report to one of your leaders here, and we look into it, because I wouldn't mind taking on some of these cases against the city, when I feel they're unfair. If they're fair, we understand that, you know. Okay, well, thank you very much.
Warren, do you, I assume you own rental property the way you're speaking?
Yeah,
In Peoria?
yeah.
Are you on Facebook personally?
No, I'm.
Well, I tell you,
with my-
we've kept this group super tight for years. Steve Sanchez, and there's not a lot of spam on that. I'm friends with your daughter on Facebook. She added me the other day. If we would love to add one of you guys to our group, we want you to be a manager, which
Okay.
you are. If you're, I'll send her the invite. We would love to have,
Well,
and she's an attorney as well, isn't she? Your daughter? Anna?
She's in law school.
Oh, she's in law school. She's almost there, but we can add one of you guys on
Yeah.
Facebook because on our group,
Well,
and
we're
you got a lot
happy
of
to give you
information.
free advice
and
on
we'd love
those
to have
code
you.
issues if you
Yeah.
got them.
Well, there's
I've handled some for the people where I didn't even charge them, you know, some people who are
okay.
trying to make it on a
Yeah.
house. And if we drag it out, if we fight the city, eventually they'll back off. And that was in the circuit court too.
Okay.
But anyway, yeah, if you got
We'll
any
get
problems,
one of you in there because
if
it's.
you got any problems like that,
okay.
give me or Mike a call,
Okay.
and we'll see if we can get you some advice at least.
I had a quick question. Do you still have to pay the city fee if you are doing a contract for deed?
No, no, you don't.
Well, they told me I had to. I've been paying it on, I have a
Well-
house I'm doing
They
contract for
made me do
deed.
that too.
Yeah.
It's my knowledge you don't.
Yeah.
How could you? Because you're not the legal owner of that house.
Well, I am until the final payment.
Well, you are,
They don't
you have a
recognize-
legal
they don't
interest in
recognize
it.
the contract for deed.
You have a legal interest in the house,
Yeah.
but,
Mortgage, or you don't have to. If you're doing a contract for deed, you still have to register it, and you can't do it.
I don't know if you know the answer to that, Mike. My understanding is you don't, so. But you do risk yourself if you do that,
I know.
because you can't just evict people then. You know, you gotta go through this big process, right, Mike? You gotta serve 30 days notice, you gotta let them recoup. It's like, almost like a mortgage, foreclosing on a mortgage. But anyway, you all know that, so. But anyway, watch that J-Max and watch the city code, people. And if you think they're taking advantage of it, give us a call.
It'd be nice if the city just followed their own rules on posting abatement notice, and they change it up. Sometimes they just send in a work crew, sometimes they post the notice to clean it for you to resolve it first.
I don't know about you, but I get these things in the mail that say you owe me $100 for
Right.
garbage or something, you know? And it goes on and on every day, you know? This is the way they make their money, that's why they pay J-Mac.
Right.
But I usually make them disclose the pictures, you know what I mean?
It's just some,
And you might wanna do this.
sometimes they
Some of
post
you,
the payment,
and
sometimes they
I'm
don't.
involved, but maybe inspect your places once a week too. Cause they'll go out and cut your grass too, right? And inspect your property once a week, drive around, maybe take some photos and catch them at it, you know what I mean? I got one location where every week they're there doing
Sounds like they're
something.
harassing you.
So I call it harassment. Anyway, their time will come. Well, thanks a lot. Thank you.
Thank you. Mike, I have a question for you. Going way back to the 5-day notice, because I recently had, actually, I'm a property that I'm a little nervous of the tenant. Me and Josh Allen, a friend of mine, went with me, and because I just, just thought it'd be safer. And somebody said, Bob, why didn't you just send it certified? Honestly, I deliver so few 5-day notices, one a year maybe. And I Googled it, I'll be damned, you can. Now, you were speaking of that. I'm a mailman for a living. I don't think, they know what they're getting in the mail. They're not gonna sign for it. If they don't sign for it, where do we stand in court?
If they don't sign for the certified mail, it doesn't work.
They have to
They
sign
have
for
to
it.
sign for it.
Okay.
Yeah. Now, anyone, good news is anyone can sign for it. It doesn't, as long
Okay.
as, so as long as you have, the statute says that, and I actually have provided that for you guys. As long as the addressee signs for it, so it can be anybody.
Does it have to be your address on the return for the certified?
Yeah, it should.
So I might recognize that.
Yeah, but like a lot of you guys said, I mean, sometimes if they just avoid it, I know a lot of you say, I just post it and I take pictures. Well, that's constructive notice then, But you have to show like a diligent effort and that they're intentionally trying to avoid service. So, I mean, like your situation, Bob, I mean, if you can show that, if they're not there at all, and you post it, that's legal too, by the way. But you have to prove that they're not, they're not there. But if that, but if they're vacant, if it's vacant, then, you wouldn't have to go through that process anyway. But, in your situation, Bob, yeah, I would definitely, just throw everything at them. I don't know how many times you've been over there, but yeah, just try to serve them as best you can, and then send it certified, and like I told you over the phone, post it too. Do it all at the same time. And most likely, they're not gonna do anything anyway, so.
It doesn't get brought up that much in court, is
Yeah,
what
no.
you're saying. I mean, if Prairie State's there, because when I was there, they had their little spiel right at the beginning, for anybody there that might need services, so they don't try to throw a wrench into, if the I would think Prairie State would attack
No.
that case anyway, any of them cases anyway.
Usually what I did then is say, well, here, listen, because I got one landlord who always posts, because it's a number, he has too many tenants. And then it's like a numbers game to him, and then usually what happens is I just tell the Prairie State, hey, listen, we're just gonna refile, and then we're just gonna reserve, let's take care of this. The purpose is to bring them to the table. And so once you get them to the table, then you can talk to them, and they're just not gonna, and then Prairie State isn't just gonna throw the case out, they're gonna, you offer them a solution, You wanna bring them to the table, and that's what we're trying to do, so.
But that still gets me. Mr. Dans, you've probably been around long back when I evicted somebody 18 years ago. You're already filing. All you want's possession. They owe money. Why does there have to be an agreement? The judge knows you're after possession. Why do you have, at that point, you're not asking for any money. When I went to eviction court 17 years ago, the judge asked, you owe Mr. Stas $800 or whatever it was. And someone argued, it's a yes or no question.
What
Yes.
I
Do you
do
want
is,
possession? Yes. Why is it such? I had to go in the hall and talk to a guy that could have punched me. Why is the court system this way? Now.
Well, that's the way it kind of operates, but on that 5-day notice, what I do, obviously I put them on their door. 95% of the time, they never question, right? I always carry an extra with me when we go to hearing, and if they want to make a beef of it, I say, well, here's your new 5-day notice right now. You know what I mean?
But I'm talking more when you get to the hearing.
You know you're gonna
What is
lose the
happening?
case in front of the judge, right,
The-
Mike?
And well, it also depends on the judge too. Now, the Judge Mack, he would always say, and he was the one last year, if you guys know him, he just wants to know two things. One, can you come to agreement? If you can't come to agreement, I'm gonna set it for trial. That's why you can't get it resolved. Now, in the past, there were other judges, and I'm sure you guys remember, like, they say, well, do you admit that you owe money? If you admit you owe money, then they would just give you a judgment, So I
Because
guess
that's
it
all
really
you're.
depends
That's
on
all
the
you're
judge,
after. You're paying for to do your job. Like you want possession of your property. If they answer the question honestly that they owe you money. I just shocked the court system has gone this far. But I'm not trying to get into that. Sorry, it's my own personal beef. But
You talked about whether you should file for eviction only or for money, right?
Yeah.
I'm just talking about eviction only because you're not going to get 90%. You're not going to get money from most of these people.
So my position is, I know you do,
Well-
money judgment, my preference is just possession only, cause it's cheaper. And even if you get a judgment, it's not like you're gonna be able to collect anyway.
That's true, but there's one thing you might know if you get a money judgment, you can always collect it somehow. And I've had people come in 4 years ago and say, hey, it's on my record, you got a judgment for $1,000. I wanna pay it cause I'm buying a house. You know what I mean? That's number one. And also, you can garnish their wages, We've done that,
Yeah,
right, Mike?
yeah.
And you can even garnish their car. And from now on, I'm gonna ask any tenant, do you have a car? Do you have any assets? What do you own? Put it down, you know what I mean?
But it's a numbers game, and a lot of us, most of our rents in here are probably $1,000 or less. If I'm going to guess, that's mine are. And it's a numbers game, and yes, you would have to pay more. Am I right, Mr. Sue? You would have to pay more to do the eviction. You're going to have to. I'm not disagreeing with you. Yeah, if you got 1,500, somebody making 1,000 a year, you probably could get some money out of them, maybe. But I guess it's case by case basis, maybe.
Right.
Um,
Here's what I'm gonna bring up, if you have a contract for deed, you can still evict people, but you have to show that, you pay less than 20% of the purchase price. Otherwise, then you gotta go through foreclosure court, which is an animal. But otherwise, you can just go through the normal eviction order. There's a few things I'd like to bring up, that I thought might be important, that Bob kind of mentioned. There's a new law that came out about application fees, this year.